Hello everyone, and a very warm welcome to today's session on digital transformation and its impact on intellectual property law. The intersection of technology and law has always been dynamic, but the pace and the depth of change that the digital era has introduced are unprecedented. What we are witnessing today is not merely an incremental change in how creative and innovative works are produced and distributed, but a complete transformation of the very foundations upon which intellectual property rests. The digital transformation, a term that encompasses the integration of digital technologies into every facet of human activity, has reshaped industries, communication, governance, and culture. It has also redefined the way we perceive authorship, innovation, and access to knowledge. Consequently, intellectual property law, which was developed in an era of tangible goods and geographically limited markets, is now under immense pressure to evolve to meet the demands of a borderless, data driven, and highly interconnected digital society. Understanding digital transformation. To begin with, let us first understand what digital transformation truly means. Digital transformation is more than just the adoption of a new technologies. It represents a fundamental shift in how societies create, share, and use information. It encompasses a wide range of innovations from artificial intelligence, blockchain, and cloud computing to the Internet of Things, virtual reality, and big data analytics. These technologies have blurred the traditional distinction between the physical and the digital, between consumers and the creators, and between ownership and access. At its core, digital transformation is about speed, scalability, and interconnectedness. A single act of creativity, such as composing a song or designing a logo, can instantly reach a global audience through digital platforms. Likewise, data can be generated, processed, and analyzed across continents in milliseconds. This interconnected reality has transformed not only economies but also the principles that underpin legal systems, especially those connected with intellectual property. Historically, intellectual property law emerged to protect tangible expressions of human intellect, that will be books, inventions, artworks, and designs within national boundaries. But the digital revolution has rendered these boundaries porous. A song composed in India may be uploaded to a server in Singapore, streamed by users in Europe, and monetized through an American platform. In this global digital chain, identifying ownership, enforcing rights, and determining applicable law have become increasingly complex. The transformation of intellectual property into the digital age. The impact of digital transformation on intellectual property law is multidimensional: legal, technological, economic, and ethical. To understand this transformation, it is essential to revisit the very objectives of intellectual property rights. Traditionally, IP law seeks to strike a balance between the two competing interests: the creator's right to the exclusive control over their work and the public's right to access and benefit the knowledge from the innovation. In the digital environment, maintaining this balance has become far more challenging. Digital technologies have made creation and distribution easier than ever before, but they have also made copying, modification, and dissemination almost effortless. A digital file, whether an image, a film, or a line of code, can be replicated infinitely without any loss of quality. This characteristic fundamentally disrupts the scarcity based logic upon which intellectual property protection was originally built. Moreover, the lines between creator, user, and distributor are increasingly blurred. In the age of social media, individuals are simultaneously consumers and the creators. Memes, mashups, remix, and fan edits populate the internet, often relying on copyrighted material, but representing new forms of creative expression. This participatory culture challenges the traditional notions of originality, authorship, and infringement. Copyright in the digital era. Copyright law has arguably been the most affected branch of intellectual property by this digital transformation. The digital environment has redefined the meaning of key legal concepts such as reproduction, distribution, and public performance. In the physical world, copyright infringement required tangible copying, producing unauthorized books, CDs, or DVDs. But in the digital world, a simple act of downloading or sharing a file constitutes reproduction. Every upload or stream technically creates a new copy of the work, blurring the lines between consumption and infringement. To address these challenges, many jurisdictions have introduced legal and technological mechanisms such as digital rights management (DRM) systems, watermarking, and encryption. These tools aim to prevent unauthorized copying or modification of digital content. Additionally, the concept of technological protection measures has been incorporated into international treaties like WIPO, Copyright Treaty, WCT, and the national laws like the US Digital Millennium Copyright Act DMCA. However, DRM systems have not been without criticism. They often restrict legitimate use such as fair use or educational access and raises questions about users' rights. In response, the courts and the policymakers are increasingly emphasizing balance, ensuring that copyright enforcement does not stifle creativity, learning, or accessibility. Another major issue concerns intermediary liability. Platforms such as YouTube, Instagram, or TikTok act as intermediaries that host user generated content. They do not directly create the infringing material but provide the means for its dissemination. Laws across jurisdictions now define their responsibilities carefully. Under Section 79 of India's Information Technology Act and the DMCA's safe harbor provisions, intermediaries are exempt from the liability if they act promptly to remove the infringing material upon notice. This reflects an important convergence of cyber law and intellectual property principles. Trademark and digital branding. The digital economy has also transformed the way trademark functions. In cyberspace, a brand's reputation is no longer confined to physical markets but extends across websites, social media platforms, and e-commerce portals. Trademarks today operate as digital identifiers from logos and slogans to domain names and hashtags. The rise of online marketplaces has made the trademark protection more critical than ever. as businesses rely on brand identity to stand out amidst global competition. However, the internet has also given rise to new forms of infringement such as cyber squatting, where individuals register domain names identical or similar to established brands to sell them later at a profit. The Uniform Domain Name Dispute Resolution Policy UDRP, administered by ICANN, was introduced to address these disputes efficiently. Moreover, keyword advertising, influencer marketing, and AI driven branding have introduced gray areas in trademark law. For example, when a search engine allows a competitor to use a brand name as a keyword for advertising, does it constitute infringement? Courts across jurisdictions have offered varying interpretations, highlighting the complexity of applying traditional principles in digital contexts. Digital transformation has also created new opportunities for brand management and protection. Companies now use automated monitoring tools, AI based logo recognition, and global watch services to track misuse of their trademarks online. Legal enforcement, therefore, increasingly relies on technology itself, an irony that underscores the symbiotic relationship between law and digital innovation. Patents and technological innovation. Patents which protect inventions that are novel, non obvious, and industrially applicable lie at the heart of technological progress. But the digital revolution has expanded the frontiers of what can be patented. Software, algorithms, and artificial intelligence systems are now central to innovation, yet their patentability remains one of the most contentious areas in modern IP law. In the United States, the landmark case Alice Corporation versus CLS Bank International 2014 set significant limits on software patents, ruling that abstract ideas implemented through a computer are not patentable unless they add an inventive concept. Similarly, in India, Section 3 Clause K of the Patents Act excludes computer programs per se from the patentability, though software with a technical application or industrial utility may still qualify. Digital transformation has also introduced globalization of innovation. Inventions are often developed collaboratively across the countries and deployed through digital infrastructure that transcends borders. This makes enforcement difficult and requires harmonization through international instruments like the Patent Cooperation Treaty (PCT) and the TRIPS Agreement. Another emerging issue is the role of artificial intelligence in invention. When AI autonomously generates a new design, process, or composition, can it be recognized as an inventor? Most jurisdictions currently says no. Only human inventors are recognized. However, as AI's creative capabilities expand, this position is likely to face pressure and re-evaluation. Trade secrets and cybersecurity. In digital economy, trade secrets, confidential business information such as algorithms, customer lists, or formulas are among the most valuable assets. Yet they are also among the most vulnerable. With data stored on cloud servers and shared across digital platforms, the risk of misappropriation has multiplied. Cyber attacks, insider leaks, and hacking incidents frequently target intellectual property databases and corporate research files. Protecting trade secrets in this environment requires robust cybersecurity measures. Encryption, access controls, employee confidentiality agreements, and network monitoring. Legal frameworks are also evolving to impose stronger obligations and penalties for digital trade secret theft. The US Defend Trade Secrets Act 2016 and similar provisions under India's Information Technology Act represent steps towards safeguarding confidential information in cyberspace. However, the difficulty lies in proving misappropriation in a virtual environment. Unlike physical theft, digital intrusion leaves minimal traces and may involve actors across multiple jurisdictions. Courts increasingly rely on forensic evidence, IP logs, and metadata to establish culpability, indicating that the enforcement of IP rights today is as much a technological process as a legal one. Digital tools for IP management and enforcement. The same technologies that challenge IP protection also offer innovative solutions. For example, blockchain technology can create immutable records of authorship, licensing, and ownership. Each digital asset can be timestamped, verified, and tracked across platforms, drastically reducing disputes over originality. Non-fungible tokens (NFTs), though controversial, have demonstrated the potential for creators to assert ownership and monetize digital art, music, and collectibles. Artificial intelligence, too, is transforming IP management. Machine learning algorithms can detect plagiarism, monitor trademark misuse, and analyze patent landscapes faster than any human team. AI-assisted IP offices are now a reality, automating file processes, prior art searches, and even initial examination stages. Furthermore, smart contracts enable automatic execution of licensing agreements, ensuring that creators receive royalties instantly upon the use of their work. This integration of law and code, often referred to as computational law, represents the next frontier in the digital IP enforcement. Challenges of jurisdiction and enforcement. Despite technological progress, the enforcement remains a persistent challenge. The borderless nature of the internet means that infringing acts may occur in one country, be hosted in another, and cause damage in the third. Determining which nation's law apply and how to enforce them becomes a daunting task. International cooperation is essential. Treaties administered by WIPO and WTO have established minimum standards for protection, but enforcement mechanism remains uneven. Many developing countries lack infrastructure and resources to monitor and prosecute digital infringement effectively. Moreover, differences in legal traditions, such as civil law versus common law, complicate harmonization efforts. Global digital governance therefore requires not only legal alignment but also technological interoperability and political will. Balancing protection with access. Another key concern is maintaining balance between protection and access. Overly rigid IP laws can stifle creativity, restrict knowledge dissemination, and create monopolies over essential technologies. On the other hand, weak protection can discourage investment and innovation. Digital transformation has forced policymakers to rethink this balance. Open source, software Creative Commons licenses, and open access publishing have emerged as a viable alternatives to traditional proprietary models. These initiatives promote collaboration and knowledge sharing while recognizing the creator's moral rights. The COVID-19 pandemic provided a striking example of this tension. Calls for temporary waivers of IP rights on vaccines and medical technologies illustrated how global crises demand flexible approaches to intellectual property, prioritizing public health and collective welfare alongside private rights. The future, artificial intelligence, big data, and beyond. Looking ahead, the future of IP law will be shaped by the continuing evolution of artificial intelligence, big data, and quantum technologies. AI generated works from visual art to music to code raise fundamental questions about human authorship and creativity. Similarly, big data analytics relies on vast quantities of information, much of which may be protected by copyright and privacy laws, creating overlapping legal regimes. As digital transformation accelerates, law must evolve from being reactive to being anticipatory. It must develop frameworks that encourage innovation while safeguarding ethical standards, data integrity, and public interest. Multidisciplinary collaboration between lawyers, technologists, policymakers, and ethicists will be crucial in achieving this equilibrium. Conclusion. In conclusion, digital transformation has not merely influenced intellectual property law, it has redefined it. It has turned static legal concepts into dynamic challenges, compelling us to rethink ownership, authorship, and creativity in a world where information moves faster than regulation. The convergence of technology and law has produced both opportunities and obstacles. Opportunities for innovation, democratization, and global collaboration, and obstacles in enforcement, jurisdiction, and ethical governance. The future of intellectual property will depend on how effectively legal systems adapt to this new digital reality. The goal must be to create a flexible, inclusive, and technologically informed framework that protects creators, encourages innovation, and serves a greater good for society. Ultimately, digital transformation does not diminish the value of property, intellectual property, it amplifies it, but it also demands that we reimagine law itself not as a static set of rules but as a living system capable of evolving with human ingenuity and technological progress. Thank you.